Good afternoon, Mr. Steven. My name is Vera Renata Ivana, and today I will present you regarding Law Assignment 2, IP or Intellectual Property Rights. Intellectual property or IP refers to cognitive creative works, including discoveries, artistic and also literary works, concept of style or design, and commercial icons, analysis, and visuals. The individuals are granted intellectual property rights over their mental creations, and they also generally give the producer exclusive rights to use his or her invention for a set period of time. There are two types of IP, which is copyrights, which is the first one is copyrights and rights related to copyright. Copyright in Malaysia protected by Copyright Act 1987, and the protection of the copyright which provided does not require registration, payment, or any other formalities. It is just an author's creative works, examples such as journals, song lyrics, artworks, and much more, are protected by copyright for at least 50 years after the death of their creator. Entertainers such as performers, singers, and musicians, also producers or sound recording and broadcasting organizations, are also protected by copyright. Copyright and related rights are aimed at encouraging and rewarding innovation. Secondly is property for industrial use, and it is classified into two parts, which is one area is the protection of distinguishing signs, such as trademarks and geographical indications, which means identifying the area of origin of a specific product or services. And the safety of these distinctive markings is aimed at encouraging and guaranteeing fair commerce and protecting customers simply by making responsible decisions between various products and services. Certain kind of industrial property were also guarded, mainly to encourage innovations, designs, and also technological advancement. This section discusses patentable inventions, design rights, and also confidential material. And the primary of objective provided by security for the result of capital invested in the invention of new technologies, thus providing an incentive and implication to finance R&D projects. A functional intellectual property rule must also make it easier to transfer the technology via foreign investments, partnerships, and also license. Sorry. In most cases, protection can be provided for a specified period, typically 20 years in the case of patents. The IP objective. The main objective of intellectual property rights is to empower businesses to create new ideas, such as technological advances, artwork, and developments, which can help to spur the financial development. The intellectual property rights upcharge individuals' opportunity to keep producing goods while also creating more job openings and new technologies, allowing our universe to continue improving and adjust at a rapid rate. And as per the US Chamber of Commerce Global Innovation Policy Center, intellectual property or IP helps create and facilitates high-paying jobs. And IP also concentrated companies hire over 45 million. Furthermore, the regular worker in an IP sector receive roughly 46% more than his or her equivalents in a non-IP sector. Intellectual property rights are classified into three types, which is first is patent, often used to prevent someone else from generating, distributing, and using an invention without consent. A patent holder has complete commercialization rights to his or her patent, and including the right to buy and trade the patent or grant a permit to the discovery to any third party on settled terms. There are two types of patent, which is utility and plant patent. Utilities and plant patent. The formation of valuable new or enhanced product, process, matter configuration, or machine is prohibited by a utility patent. Example for illustration of a utility pattern, such as, for example, MW012345 6. It is a method for implementing vehicles autonomous driving device. And secondly is plant pattern. Plant pattern is protect novel plants varieties developed through seedling and other platonic means. A trademark is a distinctive emblem that enables clients to easily identify specific goods or services provided by the company. Some instances included McDonald's golden arches, the YouTube logo, and so on. Text, a slogan, an icon, a tone, a scene, and or a shade can be used to create a brand image. And a trademark, as opposed to a patent, it can protect a group or a class of goods or services instead of one product or one process. And the ideas were not protected by copyright. It only applies to perceptible types of invention and unique research, including art, music, blueprints, and even software codes. The trade secrets of a corporation are its secrets. They are highly classified patented system, formulation, techniques, or even other data that should not be used commercially by others without permissions. And this is a specific aspect of safeguard that can help businesses achieve a competitive edge. Malaysia IP right enforcement. Registering with the Malaysian Intellectual Property Corporation, or MyIPO, offers initial permissible rights for intellectual property and is needed for the most constitutional protections except for copyright, which is protected automatically upon publications. However, due to the rise of intellectual property offenses in Malaysia, most memorable, which is fraud and theft of goods, registration on its own could not be seen to be efficient against such many committed offenders. In this scenario, active enforcement is used. Companies can protect their intellectual property through a variety of enforcement avenues, both criminal and civil. Civil lawsuit against trademark or copyright infringers is a more direct approach. Malaysia IP right enforcement. Filing a case with Enforcement Division of the Ministry of Domestic Trade and Consumers Affairs can result in the seizure of offending property, including counterfeit products or copyrights, with the goal of triggering court enforcement actions against the plaintiff. Both Section 7 of the Copyright Act of 1987 and Section 16 of the Trademarks Act of 2019 give enforcement officers broad authority to arrest suspects and search for and seize infringing items. And Section 44 of the Copyright Act of 1987 provides for a search and seizure warrant when there are reasonable grounds for suspecting a party of having copyrighted. In the case of the Kerajaan Malaysia and Ors versus Tensinyok and Anor, enforces the whole rule, stating that no damages can be retrieved toward policymakers for a legitimate seizure of assets under conduct, even if no criminal probe is initiated because of the confiscation. While criminal prosecution can be efficient, civil lawsuit often offers a broader range of solutions for all kinds of intellectual property infringement. In fact, when it's come to intellectual property, when the rights are unregistered or unregisterable, civil remedies may be the only option. For example, while an unregistered trademark owner may not be capable to use full power of the Trademarks Act 2019 to implement its allegations, the proprietor has right to appeal to the common law tort of passing off under Section 159(2) of the same Act. And the plaintiff's incapability to specifically categorize the classified documents pertaining to the contravention tends to result in the dismissal of their case of Dynacase Melaka as the NBHD versus Vision Case as the NBHD. How hotel protect their brand identity? First, they can use trademarks. Trademarks are quickly becoming an essential component of effective goods or service marketing. Hotel and eatery brands are prevalent in many areas, with optimism of continuing to function or partnership and hence expanding their company. Trademarks such as hotel staff uniforms or hotel layout can also play a role in the hospitality context. And furthermore, the following can be protected, such as a well-known one-of-a-kind dish of beverage name, one-of-a-kind decorations component, including a custom-made sculpture, a menu created on an individually basis. And secondly, copyrights. As social media usage has grown, so has the word of food plating, trending hashtags, and also online advertising campaigns. Copyright could be used to defend everything which shows intellectual creations, authenticity, and a decreased level of performance. And the company must always make certain that this is the legal owner of any creations, branding, of or advertisements created for it by any individual or agency. And some issue must always be explicitly stated in a contract that original works of authorship, such as menus, marketing campaigns, and corporate website names, are protected by copyright law. Trade secrets. As a trade secrets, these must be kept in private. It also indicates that they haven't been proclaimed because they haven't been published. Only a few of people should be privy to the recipe or the procedures from the start to finish. And their contract of employment must include confidential information, non-disclosure, and also non-competition clauses. And the firm should determine whether the trade secrets belong to the corporation or to the independent chef or employee who invented it. And due to the lack predetermined of actual ownerships, all agreements must clearly state who owns that. And lastly, we have patents. Patents, whenever an inventor creates everything that is fresh or new, he or she may register for a patent. A restaurant owner, for example, they can acquire a patent for a new edition of the kitchen gear. And a patent owner is entitled to prohibit others from producing exploitations or also selling an invention covered by the patent in any state in which the patent is implemented. Intellectual property right is licensing or IPRS. Intellectual property right licensing or IPRS, a trademark, copyright, or a patent owner may use these rights to generate additional revenue streams by awarding the third parties who interested to use these rights for a charge. And this is referred to as intellectual property licensing, and it is the core of rapidly growing practice in the hospitality sector. And merchandising is a subset of IP licensing in which the owner of IPR, commonly a trademark, product development, or copyright, grants another right to use the logo of the products, designs, or copyrights on use, and usually is on regular goods to boost the attractiveness of the goods. That's all for today. Thank you very much, sir. I apologize if I have many mistakes in my word. Thank you.